And thank you for joining us for the Office of Open Records annual training. Had some technical difficulties there in the beginning, but we're good to go now. So today we're going to be covering a few topics on the right to know law, and we have a couple speakers here with us. I am Nathan Byerly. I'm the Deputy Director. I'm going to be going over the basics of the right to know law. We'll do a quick summary of those. We found that in getting out there and doing some of the trainings post-COVID, there are a lot of open records officers and a lot of requesters as well who aren't as familiar with the laws. They've just begun using it. So I'm going to go over that. And we're going to go over tips and best practices for agencies, which is going to be covered by our Chief Counsel, Kyle Applegate, and then our Executive Director, Liz Wagenseller, is going to cover tips and best practices for requesters. So I'm going to start off by talking about the basics of the right to know law. And it doesn't get any more basic than going over some of the acronyms that are used not only here at the Office of Open Records, but by a lot of the requesters and agencies out there. OOR is Office of Open Records. You'll hear us refer to FDs. Those are final determinations. That's the final orders that we issue in cases and decisions that we make on the appeals. You'll hear us use the phrase ARROW probably from time to time. That refers to an agency open records officer. That term ARROW also will include open records officer. Another name they're called is right to know officers, right to know law officer. So basically anybody that's responding to a right to know request on behalf of the agency is going to fall under that ARROW acronym. RTKL, you might hear used, right to know law. And last but definitely not least is the acronym AO. You'll hear us talk about that from time to time. That's what we refer to our appeals officers here around at the Office of Open Records. So jumping right into the basics of the right to know law, before we even get to the basics and the procedure and how it works, we have to take a look at the purpose and the driving reason behind the right to know law, and that's to promote access to government records and government information. And the logic behind that the legislature was thinking was to prohibit secrets, to scrutinize the actions of local officials, public employees, government agencies, and to hold all of us, here at the Office of Open Records, we're government employees as well, but to hold us accountable for our actions, give the people that we work for and represent the ability to make sure that we are using government money, government resources, government time appropriately and correctly. That's a key part of this law, is to give us the accountability that we need. Every record of an agency is presumed to be public, and that was the big change that the right to know law brought about in 2009 and changing things up. And that means that the agency is responsible to prove that a record is not public. The burden is not on the requester to show that it is public or that they should be given access. That burden rests on the agency alone. And just as a side note as well, something that we run into on a consistent basis is that the right to know law is not a confidentiality statute, which means it doesn't make records confidential. It allows an agency to withhold records, but it does not require the agency to do that. So we'll see from time to time agencies will say, well, we're not allowed to release that under the right to know law, and that's not completely that's not accurate. They can withhold again, but they do have the discretion to release. And as we'll see later, there are other laws that may come into play in that right to know context. So there's two general questions when you go about looking to make a right to know request that come up. And a lot of people want to instantly jump into, well, is it a public record? And before we even get to determining whether or not something or information is a public record, we have to determine, is it even a record that is a record of the agency? Is it information that belongs to the agency? Is it subject to the right to know law? Does the right to know law apply to it? So a record, and you can see the definition there on the screen, and I'll just basically shorten it even more than that, is basically a record that documents transaction or activity of an agency, and it's kept related to that agency business. So, for example, if I send an email to my wife tonight and I say, hey, I'm going to stop on my way home, pick up some dog food and pick up some milk for us, that is a personal email. That would not be considered a record of the agency because it's not transacting any government agency business. On the flip side, if I send an email to Liz and say, hey, we're going to get together in a meeting and we're going to talk about the exception for pre-decisional deliberative records and whether or not it applies in a specific case, that clearly relates to OOR business and therefore would be a record of the agency. Now, whether or not it's a public record is another question we would ask. So first off, we establish, yes, it is a record of the agency, but is it public? And there are a number of exemptions that apply under 708B. And if the records are covered under those exemptions, the agency could withhold. We would also look at federal or state statutes or a judge's orders, because those may be things that do make records confidential or do make them mandatorily withheld. We don't want to be violating any type of court order in ordering the release of records, or if an agency has a court order, they don't want to release those in violation of a court order. And then the last thing that you would look at was, is the record protected by a privilege? And for example, attorney-client privilege being the most common one that we see there. But those would all come into play as well as determining whether or not a record is public. And now just looking at the process real quick, we'll do a walkthrough of how a right to know request goes from the very beginning to the end. So let's say you are looking to get some records from your local agency. You're interested in, maybe they're doing work on a road near your house or something to that effect. You would file a right to know request with the agency open records officer at your local agency. So like if it's your borough or your township, you would try to find out who the arrow is and then file a right to know request with them. The agency has 5 business days to respond. So many times we'll see the question come up, what's a business day? That is the day that the agency is open for business. And basically the agency will has the option to do a number of things. They can grant outright and say, here's the records, here's your copies. They can say, we'll email them to you because they're in electronic format. They can also say, come by and take a look. So there's any number of different ways they can grant access to those records and to that information. They could also deny and say that, look, these are exempt under the right to know law. They could cite a 708B exemption. They could also, as we just discussed earlier, say there's a court order that says we cannot release them. They could also cite other laws, which are making the records that you are trying to request and get at confidential or privileged in some way. So you would, as an agency, you would be able to respond that way. Requester, you could expect to have that explained to you in the denial. There's also the ability of the agency to partially grant and deny. We see this come up mostly in the context of redaction, where an agency will mark out certain parts of the records and block them out. Anytime there is a redaction, that is considered a denial and would need to be supported by the agency and explained in what capacity they're denying access to and under what section they are doing that, or again, if there's a court order or other laws that might apply. There's also the ability of the agency to take a good faith 30-day extension. And I say good faith because these extensions are not to be just automatically taken. The right to know law sets forth specific situations in which extensions can be taken. They can be, like I said, there's a number of them, but the most common is legal review, and sometimes agencies will take them for staffing. They're short on staff, so they're not able to do a turnaround as quick. Sometimes we'll see a situation where an agency may receive a number of right to know requests, and just because of the volume, they need to take consistent 30-day extensions. So again, taking extensions just automatically when you don't need to. The opposite of good faith is bad faith, and if you're an agency, you're not careful there, you could be looking at potential bad faith actions if a requester were to seek sanctions against you in court for taking those 30-day extensions inappropriately. Again, when the agency denies access to the records, they need to explain why they denied access to those. and cite the exemption, the court order, or other laws that and privileges that they are using to withhold those records. If there's no response within the 5 business days, it's considered automatically denied, and we call those deemed denieds, as does the law. It's a deemed denial, and once that happens, that denial cannot be changed. An agency's late response does not reset the clock. Even if the agency and requester agree that they want to give an additional 30 days, that does not reset that clock. It's automatically denied that date. So as we'll see in another slide, your appeal time will start to run as soon as that request is deemed denied. In the context of taking the 30-day extension, if an agency takes a 30-day extension and at the end of that 30-day extension, they must again grant or deny. And if they do not respond, that is also considered deemed denied, and that again starts the clock running. Agencies and requesters can agree to longer than 30-day extensions, and we do see this come up from time to time in the context of voluminous requests or ongoing projects that a requester may have. However, if they agree to that, any extension beyond that 30-day extension that the agency is allowed to take must be done in writing. So make sure if you work out an agreement with you as an agency and the requester that you put that in writing so that everybody is on the same page and it's memorialized for the OOR should an appeal come up. Otherwise, it's going to be deemed denied as soon as that 30-day extension runs out, and your appeal time will have passed, and you'll have to start the process all over again. So let's say you file that right to know request with your local agency, and your local agency comes back and denies under 708B for a number of reasons, or perhaps even just one. You have the opportunity at that point to appeal to our office, and our office handles and has jurisdiction over appeals related to local and Commonwealth agencies. If your right to know request involves criminal investigative records in the possession of a local law enforcement agency, your appeal would then need to be directed to the district attorney's office of whatever county in which you're making the request. I point out here that at times there can be commingled issues where there may be 708B16 is criminal investigative, 708B17 is criminal non-investigative records. We would maintain jurisdiction over the non-criminal, and the district attorney would have jurisdiction over the criminal. So if you have a situation where you make a request and you suspect that both criminal and non-criminal investigative records are involved and you were denied access to them, it is a wise approach to appeal to both the OOR and the district attorney's office. When we get the appeal in those situations, if you are incorrect and it should be completely with the district attorney's office, we will transfer it over to the district attorney's office. And if you file with both, sometimes we will dismiss them outright depending on the procedural nature of the case. But just a precautionary measure to pay attention to there if you have both B16 and B17 type records involved. The legislature, the judiciary, Office Attorney General, and several other offices listed in the right to know law have their own appeals officers within their agencies. So if you make a right to know request with those offices and you either are denied or your request is deemed denied, you would appeal to the appeals officer at those offices. You would not appeal to the Office of Open Records in that situation. We do have a mediation process. So when you file an appeal with us, you can request mediation. Keep in mind that both parties need to agree to the mediation so that you can work through that together. There will be a little more discussion on this, maybe a little more depth later on, but we have found this particularly helpful with voluminous requests or when agencies and requesters are speaking about the same records and using different language. At the end of the process, if it's not successful, it just gets transferred to a different appeals officer to go through the rest of the appeal process. So you've filed a right to know request. It's been denied. You have 15 business days to appeal. And I emphasize there it's the OOR business days. So in the days we're open for business will be what counts for your appeal time frame. And we calculate that from the date of the agency's response or the date of the deemed denial, whichever comes first. And there will be times if you think there's a time wrinkle within your request or appeal to us, it may be good to point that out when you file the appeal with us to explain if there's any date issues or reasons for it being late. We are statutorily bound by that 15 business days. So if it's late, we will dismisses it untimely. So you would have to start the process over again. So that's something that our hands would be tied on. So make sure you get those appeals in a timely manner. When we get an appeal, there's a number of things that happen for us to get it up and running for you. We assign an appeals officer. So you'll be given the name and contact information of that appeals officer. It's done so by sending out an appeal packet that notifies everyone of the submission deadlines, outlines some of the other guidelines within the process. During that process, the appeals officer will collect and accept from the parties legal arguments and any evidence submitted. The evidence that we gather from the agencies and occasionally from the requesters is written. We at this point aren't having live hearings, but we collect the evidence via affidavit. You would submit affidavit and attestations to the appeals officer. He or she will review them and then issue a final determination within 30 calendar days. And we work on a very strict statutory deadline. I mean, that 30 calendar days is what we have to issue. So that is why it gets passed on to you as the requester and agency. You also have pretty tight turnaround times to get in your legal arguments and evidence. We can extend that 30 calendar days, but only with the permission of the requester. And I challenge all of you who are requesters out there and kind of implore you, we're facing record numbers at the Office of Open Records with appeals filed. So if an appeals officer reaches out to you and asks for that additional time, it is helpful to us, not just from a volume standpoint, but there are many times that the requester may be reaching out to you because additional time is needed for further review, further legal discussion here within the Office of Open Records, or even the desire to collect additional evidence and legal argument from either the requester or the agency. So we don't ask for those extensions beyond the 30 calendar days lightly. And like I said, typically when we ask for them, it is legitimate need and we are trying to figure some things out or look at additional information that would be beneficial to both parties as we work through that appeal. The final determinations that we issue are legally binding final orders, and we are one of the few, I think we're one of three. Last I knew it was only there's only 3 states that have binding final orders, binding final order authority in the right to know or freedom of information context. That means that if the agency doesn't appeal it and you never got the records, that is an enforceable order that can be taken to court, and enforcement actions can be filed with the courts and they will back up the orders that we issue. We've even seen some orders starting to come down that are indicating that the courts might be leaning toward even bad faith findings where orders of the Office of Open Records are not followed. So we don't have anything definitive on that. We're just seeing some come down initially kind of hint and lean that way. So be aware that as an agency, if you get a final determination that directs you to release the records, that is something that is important to do and to make sure you release the records as directed in the final determination. Our final determinations are available for review on our website, on LexisNexis and Westlaw as well. So let's say you went through the appeal process, you filed a request, the agency denied you, you filed an appeal with the Office of Open Records, and you don't agree with the final determination that the Office of Open Records has issued. What's your remedy? You can then appeal to the court. You have 30 calendar days to appeal to the relevant court. And the relevant courts would be, if you file a right to know request and appeal with a local agency, it would be to the Court of Common Pleas in the agency's county. Or if it was with a Commonwealth agency like for example, Department of Health, Department of Corrections, you would file an appeal of the OOR's final determination in Commonwealth Court. The law requires that the OOR be served notice of the appeal, but we are not a party, and we should not be named in the caption. We don't see this nearly as much as we used to, but we still do see it from time to time, and do not name the OOR in the caption, because we will end up, it'll create additional work for us, and the courts will eventually take us out of the caption. So it's just more efficient for us not being named at all. I would ask, and it's not required of you, but I would ask that as a requester and agency, when you get a final resolution of your cases in the courts, if you would send us the final order, that'd be very helpful. We try to keep them updated on the website so that the public has access to both the final determination and any related court orders that come down and court opinions. And it also helps us with educating the public, and it keeps us knowledgeable of, especially at the county level, binding orders that have been issued by the courts that we need to follow. And if we don't have them served to us, we're not able sometimes to be aware that those orders have come down. Those can be delayed getting posted on LexisNexis, and I think even at times, some of those county court decisions never make their way to LexisNexis or Westlaw. So please keep us updated by emailing those to us when you can. Agency is only required in payment issues, is only required to provide the record in the current medium. So we continue to see development in this area of the law, especially with the advancements in data storage. The courts have said that pulling information out of a database is not creating a record, is not putting it in a new medium. So that is something to keep in mind. But just check back with us from time to time and check the final determinations development in this area of the law. As the law currently stands and as the fee schedule developed by the OOR currently stands, an agency cannot charge for electronic records. So I don't think there's any indication that that's going to change, but we do see that come up from time to time where agencies will try to charge for electronic records. Agencies can arrange for inspection of the records. That's part of what I mentioned in granting access. We do see this question come up where can a requester just demand that a certain time they be given access? And that is not how the process works. We need to work on a mutually convenient time that the requester and agency work out so that the requester can go and view the records. Requester can bring their own equipment to make copies. That includes bringing a cell phone and taking pictures. So to the extent that there may be sensitive information or information that the agency wants to redact before they invite the inspection, they may need to make it clear in their response to the request that certain information will be redacted so that the requester can again appeal if they desire to, or realize coming in to take the pictures that there's going to be redacted records given to them. Agency cannot charge for labor, cannot charge for redaction, and cannot charge for legal review. This is pretty standard, been accepted by the courts. We have seen this come up from time to time where there will be an attempt to charge for redaction or sometimes passing on some of the legal review expenses. But we typically see that in situations where the arrow is new to the process or a solicitor is new to the process as well. Agency can only charge the actual cost pass-through costs of record production. And where we see this is typically in specialized documents. So for example, you have maybe a large map that the agency can't reproduce themselves and make a copy. They would send that out to a third party to have the copy made. They would be able to pass on to the requester the actual cost of reproducing that document. So it's not like it's one big, huge page and it's only going to be 25 cents. They can pass on those third-party fees. The way it's set up is it's a mutual exchange of payment for the records, but payment is due first. And we, again, see this come up from time to time where an agency will turn over the records and then try to get the fee after. Make sure you get the fee first and then turn over the records. That is completely acceptable to handle it that way. Agency may require prepayment if the fees are expected to exceed $100. However, make this very clear to the requester that the fees are going to exceed $100, and if they are rather expensive fees, sometimes we see situations where the fees will run into the thousands of dollars. Make that very clear to the requester before you start any work on making the copies, to let them know it is that expensive, because many times the requester has no idea that it's going to come back to be that type of cost, and they may amend their request or narrow the request, and it will save you both time and save them money, and just be a smoother and better process for everyone. We see a question come up on a common basis on record discard. You as an agency are required to hold responsive records for 60 days. If the requester does not come and pick them up within those 60 days, you are able to discard them. And if fees were involved, an agency can deny future right-to-know requests for non-payment of previous requests.
Question about fees.
All right. Can an agency charge for USB CD if requester wants the documents on such device, or required to allow them to bring their own? We had that come up. I know that agencies are allowed to charge for USB CD. They are allowed to do that. I don't think we've had the issue come up of whether the requester can bring their own.
I believe in the past, we might have said that agencies aren't required to, there's a provision in the right to know law saying that agencies aren't required to give access to their own computers. So I think we've said that it's permissible for an agency to, charge for a new USB drive or CD-ROM instead of using the requesters, although they certainly may if they want.
All right, another question. If a document is only available in hard copy, and hopefully that answered your question. If not, please follow up with an additional one. If a document is only available in hard copy and it has to be reduced to redact, if the requester charged despite only... So if it's only available in hard copy, the requester could be charged the 25 cents per page.
Right, even if they wanted to redact, if redactions are or even if they wanted to inspect, if redactions are necessary, that copying charge can be passed along according to our fee schedule.
All right, I think that is the end of my part. Now we'll get into tips and best practices for agencies, and that will be Kyle Applegate, our Chief Counsel.
All right, thank you, Nathan. I guess I should have introduced myself before I started to talk. But as Nathan noted, I'm Chief Counsel Kyle Applegate, and I'm here to talk to you a little bit about tips and best practices for agencies in terms of responding to right-to-know law requests and their appeals. Liz will have the corresponding. Will handle the corresponding counterpart of tips and best practices for requesters. Our first tip for agencies would be to make sure you respond to all requests that are made to your agency. There could be significant consequences for not doing so. If you ignore the right to know law process, you might lose your right to prevent the release of sensitive documents or otherwise exempt documents. A court can issue fines or attorney fees and make a finding that you've acted in bad faith. It might lead to a situation where your reputation suffers, and it raises suspicions with your constituents and the public. And ultimately, if you fail to respond to right to know law requests, you're likely encouraging more right to know law requests to be filed due to suspicions regarding your non-response. So even if you're dealing with a voluminous request, a request that you don't feel like is legitimate in some way or shape, if it's a right to know law request, the law says you have an obligation to respond, so you should respond. As an agency, you could take some measures to mitigate the volume of right to know requests you might face. One of the most frequently repeated tips we give to agencies is, to the extent you can, it might make sense to post the more commonly requested records that your agency gets online. So if you receive a couple requests in a row for the same records, that might be your signal that, hey, I'm going to continue to keep getting these requests. I might save everyone some time and effort by just posting these on our website. I see there's a question. Are agencies obligated to give off docs for free via USB thumb drive or CD only, or Dropbox Google Drive? Have laws caught up with digital document management yet? Well, to answer your second question first, probably not. So it's the way our fee schedule is set up. You can't charge any fees for the provision of redacted records. Any fees that, or I mean, you can't charge fees for the provision of electronic records. Any fees associated would be for the physical medium in which you're giving those electronic records. So the thumb drive or the CD-ROM or something like that. If you were to give records, Box or Google, second that. Can you hear me now? Oh, yes. Okay. All right. Okay. So hopefully that doesn't happen again. Let's move on to some more tips for agencies. Kind of related to what I was saying before. If you have a commonly requested group of documents, it might make sense to just post the prior right to know law responses for those documents online. I see there's a question. What is an example of a commonly requested record other than crash reports? I'd say that really depends upon your agency. Well, probably the most classic requested record is a financial record or some kind of meeting minute. Make sure that your record management policies, are in place and being followed, so you could easily find records and they're easily able to be searched. Courts have noted that if you have really poor record keeping practices, that's your problem as the agency and not the requesters. So you could save yourself a lot of time and effort by making sure that your records are organized and easily accessible and ready to be searched. For the more commonly requested type of records, you're not really required to go through a formal right to know law request process. For example, if someone wants a copy of your budget and it's online, just tell the person that it's online, and that will likely satisfy that request. Might save everyone some time and work instead of drafting up correspondence. There's a question, how many years are we supposed to retain records? That would be, you might want to consult the Pennsylvania Historical and Museum Commission. They publish a guide regarding record retention that our office has. We don't really have anything to do with terms of how long you are supposed to retain records. I would direct any questions you have to PHMC. There's another question. Oh, I got a bunch of them right in a row.
Can I read them to you?
Yeah, sure. Let's go with the last one. Is there a good practice recommendation for right to know or request retention beyond the 15-day appeal window and the appeals beyond the 30 days? Um, I, I don't think we have any.
No, I've read.
You know, as long as you're following the right to know law to a T, that sounds like a good practice recommendation.
Here, so the top here. Is there a good practice recommendation for right to know? No, you did that one. Sorry, I'm trying to read. If requester requests government records for the sole purpose of selling them to others, is that an improper use of the right to know law?
No, the requester's identity is irrelevant. If a record's a public record, it needs to be provided under the right to know law.
Wouldn't use of Dropbox and the like to transmit a response to right to know requester create difficulties for the arrow if there is a second right to know request for a copy of the response provided to requester?
That might be above my pay grade.
And did you do the one about how long do we have to retain? How long do we have to retain right to know wrong?
Yes, yeah, that's that would be a good question for PHMC.
Yeah, okay. Okay, I think we're good.
Another common practice tip we provide to people or to agencies is to, you know, you're not prohibited from communicating with the requester to try to narrow down what they're seeking. Sometimes the requester is just unable to maybe clearly word exactly what they want, but a little bit of communication can go a long way in terms of clearing that up. Let's see. There's a question, are there consequences for an arrow who releases personal information, does not redact, covered by the PA constitutional right to privacy? That's an area of law that's not really kind of explored, but if you were to look at the section of the right to know law regarding findings of bad faith, you know, it's individual employees aren't, you know, held in bad faith. It's the agency. And a couple kind of presumptions are agencies are presumed to be acting in good faith as well. So if, you know, if you're discharging of your duties as an arrow in good faith under a good faith reading of the laws, I think you're in good shape. If the requester's request requires to agency to request documents from a third-party vendor and the vendor does not respond to the agency. That's a very, very narrow legal issue that you probably have to run by legal counsel. The right to know law is clear that if a third party has your public records, you have an obligation to get them from the third party. Are we required to provide birth year and or age of our employees? We have a current request. Okay, so if you have a current request, we can't provide any legal advice because first of all, we're prohibited from providing legal advice, but secondly, we might hear an appeal regarding that request. So, it might be best to direct that question to legal counsel, or our final determinations are searchable on our website. Might be a good idea to take a look on our website and see if you can find any final determinations addressing your issue. By the right to privacy, I don't. Can everyone hear me now? I just need Okay. So in terms of the question regarding work emails and phone numbers being protected by the right to privacy, I'm not aware of any court case saying that, you know, your agency issued work contact information is protected by the right to privacy. And I think there's probably a good argument that it's not. But the Commonwealth Court has found that your work issued email addresses and phone numbers might be personal and be able to be withheld under the right to know law under the exemption found in section 708B6, as long as they're not held out to the public. So if that contact information is posted online, you can't raise that exemption then.
When a record request is very non-specific, can section 7003 be cited as a reason to deny?
Yes, there's a provision under that section requiring requests to have sufficient specificity so you as an agency understand what's being requested. And I'm going to get to a slide shortly that talks about specificity a little bit.
Yeah, why don't we go through these slides and at the end we'll answer any outstanding questions.
Yeah, I agree. It looks like there's a lot of questions. Consider granting access to some exempt records. Under the right to know law, you have some discretion as an agency to release otherwise exempt records. There might be a situation where it makes no sense to go through and make some redactions. That is a case-by-case basis. Just something to consider. Might make things a little bit easier for you. Again, posting things online makes things easier for everyone. There's a provision in the right to know law that says if you could if something's publicly available online, you could then refer a requester to that. So your response doesn't need to provide the records. It could say, these records are available online, you can find them here. That response is often a lot easier to make as an agency. So a little bit of legwork up front might save you some time and effort on the back end. So as I mentioned before, some communication with the requester can solve a lot of issues. They might submit what you feel like is a fairly poorly worded request or a broad request, and they're doing so because they're trying to get all the records they want, but they might have a hard time explaining that. And it's understandable because the agency knows what records they have, but the requester might not. They just know they want records regarding a subject matter.
Yeah, and if I could jump in, Kyle, and give an example, I was presenting to a bunch of township employees, and someone gave the example. They had a woman request just extensive documents. It would have been hours of work, lots of photocopying costs for her. And they reached out to her and said, what are you really trying to get? And all she was trying to understand was how much they paid for snow removal every year for 5 years. And that saved everyone time and money. So that's an example of some requesters aren't really sure how to word it. They know what they want, but they don't know how to put it in the right words. So reaching out can just save everybody time.
Thank you, Liz. That's a great example. And the fact that you might reach out to a requester and discuss a request with them might save some unnecessary work for everyone, and it might save you some future work because if a requester is skeptical about a response you provide, they might make more and more requests. But if you can clear that up on the front end, they might not have a reason to file any more requests regarding that subject matter. So communication is key. You can't require a requester to provide a reason for the request, but you could certainly reach out to them and ask, questions about the request. A good question might be, is this the record you're seeking? And that might clear up a lot of confusion. If you reach an agreement to make a revised request, make sure it's in writing. That kind of clarity is needed for an appeal to our office. It's tough for us to handle appeals involving verbal agreements. The right to know law is not a confidentiality statute. So the exemptions found in 708B30, B1 through 30, there's 30 exemptions. None of them are required to be claimed. unlike some other laws. So use some common sense. You might be able to just provide the records outside of the right to know law to this specific requester. It doesn't mean that you have to provide the records to every single requester that asks, but perhaps the record implicates the specific requester. So, it might make sense to to use your discretion to release exempt records to that requester because it deals with them. You can't exercise your discretion if the record's protected by another law or privilege, or the agency head determines that the privacy interest outweighs the public interest. So it's just something to keep in mind there. The agency open records officer, the arrow, is the vital cog in this whole process. They're the point of contact for your agency. So it's critical that they receive right to know law training, because they're going to receive all the requests and they're going to be the point of contact for requesters and our office. The arrow is going to contact employees that might have relevant records. The same thing with contractors. So they're going to have to do a lot of legwork, reaching out, trying to locate records. They're also responsible for tracking deadlines for responses and appeals. If you miss those deadlines, your request the request might be deemed denied. And if you don't respond to an appeal in front of our office, you might be legally prohibited from raising new grounds for denial in front of a court. So it's really important that an arrow track those deadlines. An arrow, when necessary, they'll consult with the agency head or the solicitor regarding a response. There's a lot of requests that an arrow doesn't need to consult with their solicitor about, like the prototypical request for the budget, or a very commonly provided financial record or meeting minutes or something like that. The arrow can handle that by themselves without any input from their solicitor, most likely. This is very important. Make sure an alternate arrow is available when your primary arrow is out of the office, either on vacation or leave. It's just a good practice to ensure the prompt provision of public records. And you could use a resource account for right to know law requests and appeals. We keep a database of registered open records officers that we keep updated and they're posted online. Whenever you do change any contact information or change your agency open records officer, please let us know so we can update that. So Nathan went over the definition of record, and this slide kind of implicates that. But records regarding agency business are public under the right to know law, regardless what medium they're on. So this means that your personal emails, personal messages, and personal texts might be subject to the right to know law if they discuss agency business. So it's really important that you try to avoid doing agency business on your personal devices and accounts, because they might ultimately be subject to the right to know law, and you might have to provide them. A common sense practice tip is do your agency business on your agency device and keep your personal devices to your personal business. You might want to also consider mediation. The OOR has an informal mediation program that's quite successful. It's different from our normal, more adversarial appeals process in that it's outside of an appeals officer. So one of our trained mediators will handle the appeal, the parties can discuss and mediate, and it's really effective when there's a request that's broad, or that has a large number of records that might be able to be winnowed down, and both parties can come out of mediation happy. I think it's successful in roughly, 3/4 of the time, so at least partially. So it's something to consider. So someone asked a question about specificity earlier, and Section 703 of the Right to Know law deals with specificity. States that a request must include sufficient specificity to enable an agency to search for records. The courts have turned that kind of into a three-pronged test. So we're to look to see if a request has a subject matter, a scope, and a time frame. Those are three factors to consider. You don't need all three factors, but there can be situations where two of the factors are strong and the other factor is weak, and that might be sufficiently specific. But I state all that to note that it's a really complicated subjective basis for denial. And it's probably been made even more complicated with all the case law on the subject matter. We've issued hundreds or maybe even thousands of final determinations involving specificity now. If you were trying to read all of them together, you'd have a giant headache. It's a very fact-specific inquiry. And so tread carefully when you think about raising specificity as the sole ground for your denial, because we can't rule on specificity first and then give you an opportunity to raise exemptions if you're wrong. All your reasons for denial must be raised at the same time. So if you're thinking that the request might be insufficiently specific, but you also know that there's probably going to be exempt records implicated, please raise that to the OOR. You could probably raise and provide evidence of that fact, but those exemptions and reasons for denial must be raised in addition to specificity. Because if no other reason for denial is provided and we disagree with your specificity argument, we're going to have to grant access to those records. And you might not be able to introduce new evidence or grounds for denial in a court appeal. The courts have noted that we're the initial fact finder and everything should be raised before us. So just something to keep in mind in the back of your head. Try to limit your agency's raising of specificity to a minimum, because it is a very complicated reason for denial.
A couple questions, Kyle, before you leave. If a request received via email with an arrow is on vacation and is not received until they're back from vacation, does the 5-day response period start on the day of return to work?
It's the 5-day response period starts when the open records officer receives it. So if the first time they receive it is when they return from their vacation, that's when the time for response would start. That's why it's really important to appoint an alternate open records officer just to avoid those more egregious delays.
I have a requester that requests the same records multiple times per year. Can I deny the request after a number of times?
So there is a section in the Right to Know law about duplicative requests. There are certain situations that the law allows an agency to deny those requests. However, you have to show that responding to this request creates a substantial burden. And I'm not aware of any cases where that's been found yet. So if it's just a matter of a requester requesting the same thing, but it's as easy as just opening up the prior Right to Know law response and sending along the records to the requester, you're going to have to just reprovide.
When the arrow mails a reply to a Right to Know request posed by an inmate, how to determine it has expired, given the unique centralized mail?
It's a tough fact-specific instance. We, as an office,
It'll come back. It comes back.
okay.
Try now.
Okay, so
Wait, can you hear?
Can everyone hear me? Yeah.
Yes, okay.
Okay. At least 3 people can.
Okay.
Oh, 5. So what that question is pertaining to is there's a case law doctrine called the prison mailbox rule. Um, so we look to determine timeliness based upon when an inmate puts his appeal in the mailing system. There's a couple of ways that an inmate can show that. The most common way would be we look at the postmark date. If the appeal is postmarked within the 15 business days, then we would consider that appeal timely. There's a couple other ways they can demonstrate, such as a cash slip. So if they provide some kind of ledger showing that they gave the appeal to prison authorities within the 15 business days, we'll also consider that appeal as timely.
It seems like I'm pretty good, so there's the next 2.
Okay. If a request is not submitted formally as a right to know law request, but it is a request for a public record, can the requester be told to resubmit on the form to the right to know law contact to be addressed? Surely, yeah, you can do that. You could also answer the request informally outside of the right to know law. As to time frame under specificity, year or less seem reasonable. How about 5 years? I actually can't answer that question because it is that complicated of a subject matter. When you're dealing with the time frame found in a request, it really is implicated by the remainder of the request. So how specific is the subject matter? How specific is the scope in terms of what types of records are being requested? Are there senders and recipients listed? So there's a universe of requests where a year or less would be reasonable. There's a universe of requests where even 5 years would be reasonable. It really depends upon the rest of the. If someone calls the township asking questions concerning other properties or residents in the township, are we required to answer them, or should we instruct them to file a right to know form? So the right to know law isn't set up to have you answer questions. It's set up for you to provide access to public records. So if someone is just calling to ask you questions, you can certainly direct them to file a right to know law request for any documents pertaining to those questions. And I think I'm all caught up, so I'm going to pass the mic to Liz.
All right, good morning. My name is Liz Wagenseller. I'm the Executive Director of the Office of Open Records, and I'm going to talk about some tips and best practices for requesting records. All right, first one, super basic, but super important. Make sure you are submitting your request to the correct agencies. Just FYI, very rarely is the Office of Open Records the right place to go. Just because of our name and Googling right to know, people seem to think, oh, they're the depository of all the records. So we have over 900 misdirected a year. I think over 90% of the ones we receive are not really meant for us. Make sure you're addressing it to the arrow. Each Commonwealth agency has their own arrow, DEP, Department of Corrections, etc. And some may even separate them by bureau if they're a very large agency, for example, the city of Philadelphia. If you're not sure, you can always add some language. If this request is misdirected, please let me know so I can withdraw it and direct it to the proper arrow. All right, specificity, big theme here. Be as specific as possible in request. Of course, like we mentioned, your request can be denied if it's not specific enough. I cannot give you a magic formula of what to say to make sure that it's not specific enough, even if it is specific enough, even if I didn't have legal reasons I shouldn't be doing that. It's just impossible to give the perfect formula for exactly what is specific. But the idea is you're looking for a transaction or an activity of an agency. If someone says, I would like emails that Mary Smith sent about this meeting, that's pretty specific, it seems like, versus all emails Mary Smith ever sent in the last 4 years. That is pretty unspecific. I'm not saying we'd go for sure either way, but I think you can get the theme as to what is something that's very, very broad. You want to make sure, as we mentioned, 3 areas: subject matter, what it is, like the July 15th meeting about the park, the scope, type, emails, or recipient of the documents, records, and the time frame. This is the one that's most difficult to talk about. There have been denials due to specificity for emails over a week. There have been grants for records over a year. It just depends on a lot of other factors. So it's very difficult to give a very specific formula for that. Track dates and deadlines in case you need to appeal. The right to know law is very brutal in terms of the dates are black and white. There's no, well, I forgot, or I was busy that day, or forgot to check my email. It's very black and white, and it is incumbent upon you, the requester, to keep track of dates. The agency is not going to do that for you. So you need to say, okay, this is when I sent the email. So let me start the clock. That's day 0 and then day 1, right? Is that how it works, right? And then if you don't hear from them within 5 days, the onus is on you to appeal within 15 business days. There's no remedy if you fail to do so. The only remedy is to submit the right to know request again, perhaps. And remember, the agency can extend by 30 days, has to be in writing. And just keeping track of all these deadlines is incumbent upon you. And we have lots of resources on our website that can help explain those deadlines. But missing that deadline can just curtail all your efforts. If you forget to appeal on time, then you're just out of luck. There's no real remedy if your appeal is untimely. All right, consider engaging and negotiating with the agency. Agencies may be willing to work with you and talk things through to better understand your request. And they cannot require you to disclose your motive in making the request, but they can ask questions to better understand what you're actually after. The example of the snow removal situation is a good example of everyone trying to help each other out and get to the bottom of what is being sought. One thing to note, the right to know law does not apply to police recordings. This changed in 2017. Those go to the district attorneys, the law enforcement agency initially, and then appeal to the district attorney. And there's very specific things. You could find this on our website and on this presentation. Go ahead.
The court.
Appeal to the court, I'm sorry, not to the DA. But that is something that if you submit this appeal to our office, then we will just have to dismiss it because we're not the right people. Does day 1 start on the day the request is received or the next business day? The next business day. Yes. That's why email's the best, because you know versus who knows when they get the mail. Can a requester's name be redacted on a submitted request form?
You would have the burden of showing why it was redacted. So I guess the question for you would be, why would it be redacted?
Mm-hmm. We'll go to the questions at the end. Other request tips. Anticipate exemptions. Avoid walking into one by carefully crafting request, plural, so that it is dismissed with, so that it is, this is not dismissed with obvious exemption. It's a little poor wording there. Another thing, seek records. Don't ask questions. If you say, hey, why were you able to vote that way on that that road thing? What's your legal reasoning? You don't have to do that. The agency does not have to do that. So you want to ask for the records related to perhaps an action by an agency rather than asking questions. Another thing, be cautious in asking for lists. Agency is not required to create a list for you unless it's a database pull. That's a whole different situation. Instead, you want to ask for all responsive records that will produce the lists that you are trying to seek. Consider submitting multiple requests at once. It might avoid getting sort of bogged down if there's one or two. If you have a lot of things you're trying to seek, a lot of records, you may want to submit multiple requests because some of those may be super easy, quick and dirty, get them in and out. Others may take a while, and you may be able to get some records initially while you're trying to work out whether or not you're getting the other records. Another thing you may want to consider, if it's possible, learn about the database software used by the agency, because there's lots of terminology that can help your request. There's jargon like create, export, compile, format, CSV, TXT, comma delimited. So if that's something you can understand, it's helpful. Okay, so that's requesting a record. Let's say you are denied access to a record, or complete everything you requested or portion of what you requested. You still have options then. You can appeal to our office and say, you know, I think this was improperly done. So here's some tips and best practices. There are multiple reasons to consider. Some or all records are denied. If an agency redacts portions of granted records and you don't agree with those redactions. Another reason is if they don't respond by the statutory deadline. An agency not responding doesn't mean that things are automatically appealed to our office and you get to work through it there. Like I said before, you have to keep track of the timeline and then appeal to our office once you have determined that they have not responded within the statutory deadline. You can ask an agency to redact non-public portions of a record rather than deny access to the entire record. So you can push back a little bit if they say we can't give it to you because there's some stuff that you aren't allowed to see. You can say, well, I'd like to see what I can. And it may be nothing in the end. You may be very dissatisfied with they don't redact, but it's worth considering. Another reason you may want to appeal is one thing that people sometimes get confused with the right to know law is those deadlines, 5 days, 30 days for an agency to respond, does not mean they have to provide all those records within that timeline. They have to grant or deny access to the records in that timeline. So they may work out a timeline with you, say, hey, all right, we're going to give you those records, but it's going to take us about 60 days to grant them. And if 60 days has come and gone and you're not getting what you asked for, then you can appeal to our office. Fee issue. So you can also, if you think that the fees the agency is charging you are unfair or miscalculated, you can also appeal that to our office. One thing we like to say is that if you often our appeals officers may ask to get an extension. We have had an enormous surge in appeals in the last handful of years, and we have a lot on our plates in terms of the volume, but also in terms of the complication. Things are getting more complicated with a lot more case history and other things to look at. It can require extensive research. 30 days can go by very quickly when you're looking at requests for significant number or significant in terms of complexity records. So giving us an extension is beneficial for a lot of parties involved. We can have a briefing schedule allowing the agency to respond to the requester's arguments, go back and forth. A briefing schedule may also permit you to respond to the agency's arguments. But I do want to make one note here is one important part about the right to know law is the appeal process is not designed for the requester appealing to provide legal arguments. You can submit your appeal, which is a very simple form, and you can walk away and do nothing. The burden is on the agency to prove why they denied access to the records. You can engage and provide some legal arguments and poke holes in what you think the agency is saying. You don't have to. So don't feel that you have to have a strong understanding of the law in order to appeal. You can just fill out that simple form and wait for our response. Got ahead of myself. All right. You're only required to submit basic info. You may choose to provide other stuff. You don't have to. You don't need an attorney. You just need to be kind of organized. And if you have access to an attorney, it can be helpful when it's complicated or if you just kind of want to outsource some of the work. So there's only 3 requirements. You have to submit it within 15 business days of an agency denying you, fill out the 1-page form, and provide all the required documentation. You have to provide, it's all listed there, but all the records related to your failed attempt to access records, the right to know request you initially gave, the denial from the agency. We do not too infrequently deny appeals because an requester failed to provide all the documentation, but it's really quite simple. If you do want to become involved in the appeal, you can, but try to think about what would be helpful. Just saying, hey, that's wrong, they're wrong is not necessarily valuable, but if you say, this exemption is raised improperly, here's specific court cases or final determinations we've previously released, and point to specific evidence to demonstrate an agency's factual assertions may be incorrect. If the agency says, we have those records, we gave them to them, it has everything, you may want to say, actually, it does not address the records that I'm trying to get at the issue. So you may want to push back by what an agency says with are the facts of the situation. And the best way to submit evidence, if you're trying to use factual information to demonstrate an agency may be wrong, is to submit an affidavit, which is something that you sign saying that this is the case. So just saying, they're wrong may not be enough. You may have to use an affidavit. If agency cites new or additional reasons for denial, ask for an opportunity to respond. All right, so once again, your options are, they're still options, even if we agree with the agency and say, yes, those records were properly denied. One is if you feel like we made an error, this is not an error in sort of philosophy or judgment, but an error, sort of a more technical error. You can do what's called a petition for reconsideration within 15 days of receiving our final determination. It's important you cannot submit new evidence like, oh, I forgot to mention this before. It's an error that we made in the process. We have 30 days again. Another thing, the agency or the requester, you can appeal to court within 30 days of the mailing, the final determination mailing. Local agencies, Court of Common Pleas, state agency, Commonwealth Court. And this is where it gets a little more complicated in terms of fees and legal arguments where an attorney might be ideal. Another thing you can do is, let's say you got a denial and you learned some stuff like, oh, I wasn't specific enough, or, oh, they don't have records for those dates, but what if they have them for that? You can learn a lot based on the denial of an agency. So you may want to say, okay, I was denied because I wasn't specific enough, or they don't have those specific records. Let me do a new right to know request and try again. So we have a lot of questions to answer. I'm going to move over and let Kyle answer those.
Okay.
I got them. 2. All right. First off, 1 year of texts between board members for a year. Is that a legitimate request? And I guess by that it means, is it specific enough? And I would say it is a legitimate request. That is something you can ask for. However, the issue of whether or not it's specific enough would involve a lot of analysis, and just some of the things we would look at would be like, how many board members are there? What's the subject matter? How many texts were sent? Just things that would make it insufficiently specific so that the agency would have no idea what the requester was trying to get at or trying to get access to.
Yeah, to add on to that, the exact wording of the request would be key.
Any recourse for an agency who has a repeat requester, threshold number submitted, is there one, and within a certain amount of time?
There's no limit on the number of requests a requester can make, or the number of records requested. I would direct you to section 506A of the right to know law. There's a section regarding disruptive requests. I mentioned it before. It's a pretty high hurdle for an agency to meet. You really have to show that a requester's made the same request for the same records multiple times, and it's caused you an unreasonable burden.
Can you appeal, and I haven't seen this one come up, this one's interesting. Can you appeal the poor quality of records? So for example, first generation PDF scans versus the searchable text, newer PDFs. So to me, I'm thinking that it would depend on whether or not you could read the original PDF. So if you can't read the original PDF, then I think there's going to be a major issue. If the issue is just you can't search and find things within the PDF, then it's going to be in the format that the agency has it, and that's what they have to provide.
Right. We've had a couple appeals over the years involving the quality of a scanned document. If you're dealing with just in terms of I can't read it, the issue becomes, does the agency have a better scan? And can the agency make a better scan? But if it's just in terms of, I want this super duper fancy searchable version, you might not be successful there as a requester.
And again, on some of these issues, as much as I hate to say this, it does not hurt to file an appeal and
Right.
challenge it to the Office of Open Records. And I tell agencies this too. If you deny and you think you're on solid legal footing, there's nothing wrong with denying that. And if the requester brings it to us and we disagree, as long as it's a reasonable legal argument, there's not going to be any ill feelings from the Office of Open Records regarding, your legal decision. We may end up disagreeing, but, beyond that, there will be no ramifications from us or, ill will again, like I said. Requester asks for an Excel file. Can the agency give it in PDF or choose a similar format or file type to give it to the requester?
The right to know law says you need to provide it in the medium that it exists in. We've differentiated medium from format. So long story short, we've held that an agency can provide a PDF copy of an Excel document. As to whether that's wise or not, that's your call.
Yeah, because generally speaking, I don't know that unless there's any harm in giving it to them in Excel. I've heard the argument made that, well, Excel can be manipulated or Word can be manipulated, but I mean, you as the agency hold the original, so there's not going to be arguably any allegation that you gave them that record. You hold the original information. However, I know arguments can be made that Excel and Word providing it in that format would be problematic. So that's basically where the status of the law is in respects to that aspect. Another question was, what happens if I have a requester who will not accept the fact that records do not exist? How is that handled?
If I was to give a practice tip here, it would be perhaps with your response, you might want to preemptively include an attestation or affidavit explaining why the records do not exist. That way, it's already executed, and if the matter is appealed to us, you already have that as evidence to rely upon. So that would be my tip there.
Any ADA accessibility tips with respect to data sharing? I don't know that we've seen that come up very much. Again, the ADA accessibility aspect would be outside of our jurisdiction. That would be a different area of the law. And if you ran into a situation where an agency may not be complying with the ADA, that would go down a different route than before the Office of Open Records.
Yeah, the only tips I could offer there is they might be a little too common sense, but communicate and be reasonable.
I believe I covered all the questions, and I believe we have. If we didn't get yours, feel free to ask it now, or if you want clarification on one and we didn't quite answer it, please feel free to do now, and we'll give you a few more minutes to do that, and then we'll wrap things up. and like we said, this will be, the PowerPoint's available on the website, so you can go look at that. You can also go look at our website for a number of additional helps. We have guides on there. We have videos on there. We have just tips, these tips and more for agencies and requesters alike. What, I can't see the top of that one, do you know?
Yeah.
Oh, I can get it, hold on. Come over.
Is there any likelihood of right to know being modified to preclude requests simply for business or for profit? Yes, there is. There has been over the past number of years legislation and proposed legislation to address what are called commercial requesters. There's also been legislation proposed to cover what are termed vexatious requesters. However, none of that legislation has passed to this point. So if you seek additional updates, feel free to touch base with us off and on throughout the year and throughout each legislative session. But to date, nothing has come about from those efforts.
Okay, so outstanding questions from oldest to newest. Would you please be able to offer specific guidelines on what types of videos should be released when requested through a right to know law request? How do you handle surveillance videos in and around the buildings and school bus surveillance videos? Because the release of those videos could compromise safety.
The burden is, again, the burden is on the agency to demonstrate why those pose a security risk. It's not just enough to say, well, it poses a security risk. You're gonna have to explain why. The Supreme Court has recently ordered school bus videos released. The faces of minors need to be redacted or blurred out. We've also had cases where security was involved with a surveillance video from it was a municipal building or a township building. But anyway, what the court looked at was you have to explain how in detail these are going to be a security threat. And where that becomes relevant is if the cameras are outside and it's a publicly accessible area and you can view everything just sitting outside that the video would record, then you are not going to be able to sustain your argument that it's a security risk because that can all be observed from the outside. Same on the inside. If it's publicly accessible, a person can just sit there and observe everything that's going on. It becomes a different issue when you're inside an office or inside an area where the security surveillance cameras are not, and that area even is not available to the public.
Mm-hmm. One practice tip I would offer to the agencies would be don't just rely upon the argument that releasing the video would show blind spots. We get that argument made a lot. You need to do more in terms of show how, how those blind spots would create a security risk. There's a second part to the surveillance video question. Often students are present in the videos. Are these considered exempt from being released to a right to know?
Yes, you would blur out their faces, is what the Supreme Court has said is acceptable.
Correct.
A number of other states do that. From what I understand, the software is relatively easy to obtain and is available even through YouTube, I believe.
All right. Might the OOR considered a more second level training for those of us with many years of experience with the basics, perhaps highlighting some particular precedent?
Yes, we can do that and we'll note that.
Oh, what am I doing? I think I got it back. Is there anywhere that has a list of top 20 or so on common requests or something that lists things that might be outside the norm for request ambiguity or issues about can be fulfilled or maybe should not be fulfilled?
That's kind of tough because the right to know law, one of the challenging things with even amending the right to know law we've seen over the years is it touches literally every aspect of life. So anywhere from records involving, like we just talked about, surveillance videos with children, you'll see emails discussing, agency business, all the way up to people trying to get, records related to the passage of legislation, PennDOT, Department of Health, Department of Corrections, and then it trickles down into your local townships and agencies. There's really just a wide variety of different records that are at issue. So that's kind of difficult to pin down. Financial records a lot of times get requested. We see that because people want to see how money's being spent. But a lot of times those don't get to us necessarily because they're so black letter public record.
Yeah, and just because it's an uncommon request doesn't mean it's somehow illegitimate. All written requests for records must be responded to under the right to know law.
And another, tip for agencies is make sure you keep track of your records, and don't keep records you don't have to. I mean, you're, as an agency, you get a right to know request, you're on the hook for those records. One of the ones that I laugh about and looking back is we once had a request. Somebody asked for information related to what Quaker women were wearing in a certain time period. And we kind of laughed at it, but if you have records, and Pennsylvania is old enough to have those records, if you have those records in a township basement somewhere, under the right to know law, you're going to have to provide access unless you can give some type of exemption. So I'm not advocating, make sure you text with the PHMC before you go discarding any historical documents. I want to note that right there with this.
Do different state agencies have department-specific right to know law tip sheets or sheets for municipalities?
I'm not sure. I mean, we have things on our website that you can access. I'm assuming that some of the agencies probably have guides. It's not a bad idea to have a little bit of a requester guide on your agency website to help them walk through the process. I know a lot of times requesters will reach out to us and be a little upset that agencies have their own forms and require their own forms, which they're allowed to do. They also have to accept the OOR's form. But a lot of times those forms help the agency process your request quicker. There's not any type of ill intent meant. They're just trying to narrow it so that they can have you ask a specific request and ask a request that helps them respond faster.
Can a staff member send a right to know law response on behalf of the Arrow? I'll answer this one, Nathan. The law is written so that it contemplates the open records officer issuing the responses. However, if a staff member was to issue one on your behalf, I'm not aware of any repercussions that the law has. So hopefully that's a clear enough answer to that statement. But Section 502B of the law does contemplate that the open records officer themselves will issue the response. When responding to a request from an inmate, if the Arrow's responses continuously keep getting returned as undeliverable, how much effort should the Arrow put into getting the record to the inmate, even if using the exact address that the inmate asks you to send the response to?
Is DOC still using the Florida Processing Center? It kind of depends on where the inmate is housed. I would check with Department of Corrections if it's within the corrections jurisdiction, because they do have a mailing point where you are supposed to direct your correspondence to the inmates.
Is a copy of a grievance against a school district allowed to be requested?
Well, if it's a record of the agency, then yes, it can be requested. Now, is it a public record? That will depend on the exemptions within 708B. And if you request that record, the agency will have the opportunity to explain to you why you should not have access if they feel you should not have access under the right to know law.
Who pays the blur or responsibility to edit video?
Who pays to redact? What is it again?
Who pays to blur or responsibility to edit video?
Well, it would be the agency's responsibility to provide a redacted record if they need to provide a redacted record.
Mm-hmm. If you have any questions about fees, they're set forth in Section 1307 of the Right to Know Law. And there is a subsection 1307G that talks about necessarily incurred fees that might be at issue depending upon the circumstance. Is there guidance regarding a good faith search for responsive emails where the request is for keywords between agency personnel? We could usually narrow down to a most likely group of people who may have transacted business related to those keywords, but the concern is whether we can ascertain all agency emails agency-wide. So the law requires you to conduct a good faith search. It doesn't require you to conduct a search, beyond a reasonable doubt. To to determine whether an agency has conducted a good faith search, we as an office look to, whether all the relevant custodians have been contacted. So if you're able to identify a group of the people who would most likely possess those records out of your agency, that's a good sign that you're probably conducting a good faith search. Township secretary who can barely answer phone or request or pay for format change. I'm not following those questions, Steve.
Just resubmit.
Yeah.
If you could resubmit those questions to us after the training, we can answer. Is an arrow able to release criminal records that are relevant to an incident that the requester was involved in, whether the victim or suspect defendant? That might depend if you're a criminal justice agency or not. You do have some limitations under a statute called CREA regarding the dissemination of some criminal information. So, depending upon that, you might have to consult with your solicitor. Will you be reviewing some of the right to know law cases from 2022? I believe past trainings included a case review. We're not doing that in this PowerPoint presentation. However, if you have any desire to review recently issued case law regarding the right to know law, we do keep a running list of case law on our website called the Case Law Index. You might want to consult that just for a review. Do you have anything other than?
No, I think it's safe to say it's been relatively quiet as far as any groundbreaking decisions. There's been a lot of clarifications on some issues, but it's highly technical. Is that a correct assessment, you think?
Yeah.
That followed who?
Nobody understands.
Oh, so was that about electronic redaction?
Yeah.
So electronic redaction and blurring, if the agency would still be responsible. If they have the capability to do it, they're still responsible to do it regardless of the personnel's knowledge. We recently held that in a final determination where the agency had the ability to electronically redact documents, but the people they had did not know how to use the software. If you have the capability, you're still responsible to redact that information. In the case of videos, out. And again, I would point out in these type of situations where you have questions that get into these technicalities, it's worthwhile if you're a Commonwealth agency to touch base with your agency counsel. If you're a township or borough or a local agency, it's worthwhile to touch base with your solicitor and to get legal guidance so that you are sure you are on good footing as you respond to these requests, and then eventually, if it comes to that, respond to right to know appeals before the Office of Open Records. And they're posted up there as the case law index that can be found. Just as a note, we are transitioning over to a portal e-filing system. I'm just giving you a heads up as you see some of your appeals will be impacted by that. We're looking to have the portal be completely live for everyone in early spring, well, hopefully early 2023. So check back at our website for information on that as we develop and become more technologically advanced here at the Office of Open Records. Any more questions? I'll give you a couple more seconds and then we will wrap it up. All right. Well, thanks so much for joining us. Again, if you have any questions in the future, feel free to reach out and we will look forward to hearing from you and talking with you all in the future sometimes. Take care. Thank you.